Welcome back to Deep Dive Daily. It is honestly great to have you here with us.
Great to be here.
You know, I was thinking about software updates this morning. It's a bit of a strange analogy, but bear with me.
Okay, I'm listening.
You wake up, your phone is updated overnight while you were sleeping, and suddenly the buttons are in different places, the colors are slightly different.
Right. And maybe a feature you loved is gone, or a new one you didn't ask for has appeared?
Exactly. But the phone, the hardware is still the same. It's the same physical device, just running on new rules. The core functionality is there, but the user interface has evolved.
It's the same device, just a new version of the operating system, a new OS.
Exactly. Now, I want you to scale that feeling up, way up. Not a phone in your pocket, but a civilization, a democracy of over 1 billion people.
A country that is, let's be honest, messy, loud, incredibly diverse, and, well, just unbelievably complex.
How do you run a software update on a nation like India without crashing the whole system, without bricking the entire country?
That is the billion-dollar question, or in this case, the billion-person question. And it's a question the founders of the country obsessed over.
Today, we are taking a shortcut to understanding that operating system for the world's largest democracy. We're looking at the rulebook, the Constitution.
But not just reading the rules as they are.
No, we are looking at the mechanics of changing them, the how-to guide for a national software update. Imagine a rulebook that controls 1 billion lives. Is it carved in stone, immutable for centuries?
Or is it written in pencil, easily erased and rewritten whenever the political mood strikes?
The answer is, and this is what's so fascinating, a contradiction. It is somehow both.
And understanding that contradiction, that tension between stability and flexibility, between being a stone tablet and a Google Doc, that's really the key to understanding modern India.
Today's mission is to unpack Chapter 10, Amendment of the Constitution. And I really want to set the expectation right now because I know how heated these topics can get.
Oh, absolutely.
We are not looking at the politics of the day. We are not interested in the shouting matches on cable news or the viral tweets about who said what.
No political drama today. We are deliberately stepping back from that. We are strictly looking at the machinery.
We're focusing on the acts, articles, and the legal framework. We're popping the hood, looking at the engine itself. We're looking at the gears and levers that allow this massive, complex engine to run and, more importantly, to be serviced and upgraded over time.
Which is often the most interesting part, if you ask me. It's where the real power lies. Our source material for this deep dive is a detailed analysis of Indian polity, and we're zeroing in on one particular part.
The star of the show.
The star of the show. Article 368 and Part XX of the Constitution.
We've got the procedure laid out step by step. We've got the criticisms, and there are many. We've got the different types of majorities, which involves some surprisingly tricky math. So, get your calculators ready.
Chuckles. Well, we'll try to make it simple.
And some really heavy-hitting quotes from the founding fathers like Nehru and Ambedkar, who were thinking about these exact problems over 70 years ago.
These are the blueprints of the system. Reading their words helps explain how you design a nation to evolve without losing its fundamental identity.
Okay, let's unpack this. We're going to look at the machinery that allows the Indian Constitution to breathe. Because that's what it does, right? It breathes, it changes.
It absolutely has to. The source material makes this point very, very early on. If a constitution doesn't breathe, if it can't bend, it will eventually break.
It suffocates the very nation it's supposed to protect.
Exactly. But before we get into the actual mechanics of voting and bills and all the procedural stuff, we have to look at the what. What is the core philosophy here? Why was it designed this way?
Right. And to understand where India sits, the source material draws a really useful comparison between two major global players, Britain and the USA. It creates this spectrum of constitutions.
It's a great way to frame it. You have to look at the extremes to understand the middle ground. So on one end of the spectrum, you have Britain. The text describes the British Constitution as flexible.
Flexible sounds nice. It sounds accommodating, like a good yoga instructor.
In a legal sense, flexible means it's relatively easy to change. In Britain, there isn't this massive sacred distinction between a constitutional law and an ordinary law.
So how does that work in practice?
The Parliament can change the Constitution in the same manner as they change traffic law or a tax code. A simple majority vote on any given day can alter the fundamental rules of the country.
So my analogy from earlier holds up. Britain is like a Google Doc.
It is.
You have the edit access, you go in, you type a few new sentences, maybe delete a paragraph, you hit enter, and boom, it's updated. Instantly, everyone sees the new version. The barrier to entry for making a change is very low.
That's a very fair comparison.
No.
It's a system that's highly responsive to the will of the parliament at that specific moment. Now, let's swing to the completely opposite end of that spectrum,
Yeah.
to the USA. The text describes the American Constitution as rigid.
Rigid. That sounds less like yoga and more like my back after a long flight. It sounds painful and difficult.
Rigid in this context means it is incredibly monumentally difficult to change. The hurdles you have to jump over to amend the U.S. Constitution are just enormous.
What are we talking about here?
You need these huge supermajorities in both houses of Congress, and then even if you get that, you need ratification by 3/4 of the states. 3/4.
Wow, 75% of the states have to agree.
Yes. It's a system designed to be static. It values stability and permanence over speed and responsiveness.
So if Britain is a Google Doc, the USA is a stone tablet. You can change it, but you better bring a chisel and a sledgehammer, and you're going to be sweating for months, maybe years by the time you're done.
Precisely. And history shows this. The U.S. Constitution has been amended, 27 times in over 230 years. It's almost frozen in time by design.
So this was the choice facing the Indian founding fathers in the late 1940s. Where does India fit on this spectrum? Do we want a Google Doc or a stone tablet?
And what they chose, the text says, is a synthesis of both.
It's neither wholly flexible nor wholly rigid. It tries to find that sweet spot in the middle.
There's a quote here from Casey Ware in the text. He says it strikes a good balance, but you have to ask why. Why land in the middle? Why not pick a side?
And the answer seems to be that this balance wasn't an accident. It was a very, very deliberate choice.
You have to remember the context. India is unbelievably diverse, it's huge, and in the late 1940s, it was a brand new nation going through a massive, traumatic transition with the partition.
So stability was key.
Stability was key, but so was progress. The Founding Fathers were looking at these other nations and trying to cherry-pick what would work for a deeply ancient civilization that was trying to become a modern nation-state.
And we have some amazing insights here from Pandit Jawaharlal Nehru. He had a very specific, almost poetic view on this. He warned against making the Constitution too solid and permanent.
Right. Nehru's argument was just fascinating. He said that if you make a constitution too rigid, too permanent, you stop the growth of a living, vital, organic people.
I love that phrasing, organic people. It's not a machine, it's a living thing.
It implies that the country itself is a living organism. It grows, it sheds skin, it changes shape over time, and the shell, the Constitution, has to be able to grow with it.
If the shell is too hard, the organism inside either dies or shatters the shell.
Exactly. If you trap a growing, dynamic society in a rigid cage of laws written in 1950, eventually that society will explode the cage. Nehru wanted to build in a release valve to avoid that explosion.
And Dr. B.R. Ambedkar, the architect of the Constitution, backed this up brilliantly. He argued against putting what he called a seal of finality and infallibility upon the Constitution.
Finality and infallibility, those are such heavy words.
They are.
He's basically saying, look, we're not gods. We are just people doing our best to write a document for the future. We know we might have missed something. We know that 50 years from now, the world will look different in ways we can't even imagine.
It's a very humble approach, actually, when you think about it. It's an admission of imperfection from the very start.
It is. Ambedkar explicitly wanted a procedure that was facile, which means workable or easily managed, unlike the incredibly difficult processes in places like Canada, America, or Australia. He wanted to avoid that stone tablet problem at all costs.
He didn't want future generations to be slaves to the past.
That's it, perfectly. So the philosophy is established. Don't make it too hard. Don't make it too easy. Make it just right.
The Goldilocks Constitution.
The Goldilocks Constitution. Now let's get into the gears. This is where we leave the philosophy seminar and enter the engine room. What is the actual legal basis for all of this?
Okay, bring on the jargon.
The star of our show today, as we mentioned, is Article 368 in Part XX of the Constitution.
Article 368. This is the one article that holds the fate of all the others in its hands.
Essentially, yes. This is the article that grants Parliament the power to amend. And the text is very specific about the scope of that power. It says Parliament can amend by way of addition, variation, or repeal of any provision.
So they can add new rules, they can tweak existing ones, or they can just delete things entirely.
Within limits, which is a massive plot twist we'll get to later in our deep dives. But yes, for now, Article 368 provides the power, and just as importantly, it lays down the procedure.
Okay, let's walk through that procedure step by step. This is Section 2 of our deep dive. I want to know exactly what happens from the moment someone has a bright idea to change the Constitution to the moment it actually becomes law.
All right.
Let's say I'm a member of Parliament. I have a bright idea. Walk me through the bureaucratic nightmare I'm about to endure.
The losses. It is definitely going to be a headache, I can promise you that. So let's trace the journey of a constitutional amendment bill. Step 1, initiation. Where does it begin?
Okay, where do we start?
The bill must be introduced in Parliament. That means it can start in either the Lok Sabha, the lower house, the House of the People, or the Rajya Sabha, the upper house, the Council of States.
Okay, so it has to be at the federal level.
Hmm.
What about the states? Can a state legislature start this process? Let's say the assembly in Maharashtra or Tamil Nadu decides, hey, we've identified a problem, we need to fix the Constitution. Can they draft a bill and send it up to Delhi?
No, absolutely not. The text is completely explicit on this point. An amendment cannot be initiated in state legislatures.
Wow, that is a big deal. That is a massive centralization of power right there at step 1.
It is. It's a fundamental design choice. In the U.S., for instance, states can play a role in proposing conventions to amend the Constitution. It allows for a more federal, bottom-up approach.
But not in India.
In India, the ignition key for constitutional change is held strictly by the parliament in New Delhi. On this specific issue, the states are passengers in the vehicle, not co-drivers.
Okay, so we're in Parliament. Who can actually introduce the bill? Does it have to be a minister? Do I need to be in the Prime Minister's cabinet to get this ball rolling?
And here's an interesting nuance. No, you do not. The bill can be introduced either by a minister or by a private member.
Wait, you need to clarify that for the listener. What exactly is a private member? It sounds like a membership to an exclusive club.
Chuckles. It does. But in parliamentary terms, a private member is simply any member of parliament, an MP who is not a minister in the government.
So it could be an MP from the main opposition party.
It could be. Or it could even be an MP from the ruling party who just doesn't hold a government portfolio, a so-called backbencher.
So theoretically, a rookie MP sitting in the very last row who nobody's ever heard of could stand up and propose a constitutional amendment?
Theoretically, yes. It's not common for them to succeed, but they have the right to propose it. And here's another key point from the source. It does not require the prior permission of the president.
So you don't need to go to the head of state and say, may I please suggest a change?
Nope. You don't need to ask for permission to bring it to the floor. You just draft the bill and introduce it.
Okay, so the bill is on the floor of the House. Now comes the voting. And I am assuming a simple aye or nay majority wins isn't going to cut it here.
Not even close. If it were a standard vote, that would be the flexible British model we talked about.
Yeah.
This is where the rigid part of India's synthesis kicks in. This requires a special majority.
Here is where it gets interesting and a little mathematical. The text defines this special majority with two very specific conditions that have to be met.
Right. And this is the most common point of confusion. To pass the bill, you need to satisfy two distinct criteria simultaneously. It's a two-part test.
Okay, hit me with the math. Let's break it down.
Condition 1, you need a majority of the total membership of the House.
Define total membership. Does that mean the people who are actually there on the day of the vote? Or does that count the empty seats, the members who are out sick, the people stuck in Delhi traffic?
It counts everyone. Total membership means the total number of members comprising the House, irrespective of any vacancies or absentees.
Okay, so let's use a real number. The Lok Sabha has a total strength of 543.
Right, 543. So condition 1 says you need more than 50% of that total number to vote yes. So you need an absolute minimum of 272 votes, period.
It doesn't matter if only 400 MPs showed up to vote that day. You still need 272 ayes.
Precisely. That 272 is a hard floor. You cannot go below that no matter what. That's the first hurdle.
Okay, what's the second?
Then comes condition 2. You also need a majority of 2/3 of the members of the House present and voting.
2/3. That's roughly 66.7%.
Mm.
That is a very high bar in any legislature.
It's massive. And you need both. Let's play this out with a scenario to show why it's so hard. Let's stick with our Lok Sabha example. Total strength is 543. The hard floor for condition 1 is 272.
Got it.
Now imagine it's a controversial bill, and on the day of the vote, only 450 members are present and voting.
Okay, 450 people in the room.
Now you have to apply condition 2. You need 2/3 of those 450 people to say yes. 2/3 of 400 is 300.
So you need 300 votes to pass condition 2.
Correct. And in this scenario, if you get 300 votes, you've also passed condition 1, because 300 is more than the 272 you needed. so the bill passes.
Okay, that makes sense. But what if fewer people show up?
Now let's try a different scenario. Let's say it's a Friday afternoon and only 360 members are present and voting.
Okay, 360 MPs in the room.
The government is really pushing for this amendment. They whip their members and manage to get an overwhelming victory. Let's say they get 250 votes for and 110 against.
250 out of 360. That's almost 70%. That's well over the two-thirds requirement. So they pass Condition 2, right?
They do. They pass Condition 2 with flying colors. But wait, what was Condition 1?
Condition 1 was 50% of the total. Half of 543 is 272.
Exactly. They got 250 votes. They needed 272. They failed Condition 1. The bill dies.
I see the safety mechanism now. It's brilliant. You can't just wait for a rainy day when the opposition stays home and then sneak a massive constitutional amendment through with a handful of your own people.
Precisely. You need the room to be relatively full, and you need a supermajority of those people to agree. You have to clear both hurdles. It forces broad consensus. You can't just ram it through with a slim temporary majority.
That is a tough threshold. Now, this process has to happen in both houses, right? The Lok Sabha and the Rajya Sabha.
Independently.
What happens if the two houses disagree? Usually, for a normal bill, if the Lok Sabha passes it and the Rajya Sabha rejects it or changes it, they can call a joint sitting, right? Like a big family meeting in the Central Hall to hash it out.
For ordinary legislation, yes. If there's a deadlock, the president can call for a joint sitting. And because the Lok Sabha has nearly twice as many members as the Rajya Sabha, the will of the Lok Sabha usually prevails.
But not for this.
Not for constitutional amendments. The text is crystal clear on this. There is no provision for holding a joint sitting.
Wow. So if they disagree, if the Lok Sabha passes it and the Rajya Sabha says no,
The bill is dead. End of story. It just lapses. Each house must pass the bill separately by that same special majority in its own chamber. It's a double lock system. Both keys have to turn independently for the door to open.
that definitely adds to the rigid side of the scale. It gives the Rajya Sabha, which represents the states, an absolute veto. It forces the government of the day and the states to be on the same page.
It's a huge pillar of India's federalism.
Okay, so let's say a miracle happens. The stars align. The bill passes the Lok Sabha with a special majority, and then it passes the Rajya Sabha with a special majority. It's cleared Parliament. It goes to the president's desk for his signature. Can the president say no? Can he veto it?
Not anymore.
Not anymore. That implies a story. There's some history there.
There is. In the early days of the Republic, there was some ambiguity about the president's power in this regard. But the text cites a specific change in the law, the 24th Constitutional Amendment Act of 1971.
What did that do?
This act, passed during a period of intense conflict between the parliament and the judiciary, changed the game. It made it obligatory for the president to give his assent to a constitutional amendment bill.
Obligatory. That's a strong word. So the president's basically a rubber stamp at this stage.
In this specific context of a duly passed amendment bill, yes. The text is clear. He cannot withhold his assent, and he cannot return the bill to Parliament for reconsideration, which he can do with ordinary bills. Once Parliament clears those incredibly high hurdles, the president must sign it.
And once he signs it.
It becomes a constitutional amendment act, and the Constitution stands amended.
So let's recap that flow because it's complex. It has to start in Parliament, no states allowed. It can be introduced by any MP, minister, or private member. It needs that crazy two-part special majority in both houses separately with no joint sitting allowed if they disagree. And finally, the president has no choice but to sign it into law.
That is the core engine of amendment as laid out in Article 368.
But wait, here's where the source material clarifies something really important. I was reading this and it struck me that while Article 368 is the main engine, it's not the only way. There are actually 3 distinct ways to change the Constitution. It's not a one-size-fits-all process.
That's right. This is one of the synthesis aspects we talked about. The framers created different levels of difficulty for changing different parts of the document. We need to distinguish between what is technically an amendment under Article 368 and what is just a change to the Constitution's text that happens outside that framework.
So the text outlines 3 pathways. Let's call them easy, medium, and hard.
That's a good way to put it. The 3 pathways are by simple majority, by special majority, and by special majority plus state ratification.
Let's break these down because the differences are huge. Pathway 1, by simple majority, the easy route.
This is the flexible British-style part of the synthesis. These are provisions in the Constitution that can be amended by the 2 houses of Parliament simply by a majority of members present and voting.
Just like an ordinary law, no special math, No two-thirds, no total membership calculation.
Exactly. And crucially, the source notes that these amendments are specifically and explicitly excluded from being deemed amendments under the procedure in Article 368. They happen outside that rigorous framework.
This part really surprised me when I was looking at the source. The list of things that fall into this easy bucket is shocking. At the top of the list, admission or establishment of new states. And even more so, alteration of areas, boundaries, or names of existing states.
It is wild, isn't it?
Think about the power dynamic there. If the parliament in New Delhi, with a simple majority, decides, you know what, we don't think the state of Uttar Pradesh should be that big anymore, we're going to cut it in half, they could just do it.
With a simple majority vote, they don't need the special math. They don't even need the state's permission.
That is just shocking to me. I mean, in the U.S., if the federal government tried to unilaterally redraw the borders of Texas without asking Texas, there would literally be a civil war.
Blacks, absolutely. But this goes right back to the DNA of the Indian Constitution and the anxieties of the time. The founders were terrified of the country breaking apart. Remember, they were living through the trauma of the partition. They wanted an incredibly strong center.
So they created a system where the union itself is indestructible, but the states that make it up are not.
Precisely. The map of India is not sacred. The states are, in a constitutional sense, just administrative boundaries drawn by the center, which the center can redraw whenever it deems necessary.
And putting that power under the simple majority rule makes it an efficient, if ruthless, tool for national reorganization.
It is efficient, but it definitely shows where the ultimate power lies.
What else is in this easy bucket? What other fundamental things can be changed with a simple vote?
A lot of what you might call parliamentary housekeeping. The rules of procedure for Parliament, the privileges of Parliament and its members, the salaries and allowances of MPs, the quorum required to actually run the House.
The practical, day-to-day operational stuff?
Yes. Also, language. The use of the English language in Parliament or the use of the official language. And another big one, citizenship. The rules for acquisition and termination of citizenship are set by a simple majority law.
And the judiciary.
Some aspects. For instance, the number of puisne judges in the Supreme Court.
Puisne. That's a word I haven't heard since law school.
It just means any regular judge who isn't the Chief Justice. So Parliament can increase or decrease the number of judges on the Supreme Court with a simple majority vote.
Okay, so pathway 1 is for the operational, administrative, and structural evolution of the state. It is the Google Doc part of the Constitution designed for flexibility.
Correct. Now we move to pathway 2 by special majority, the medium or standard route.
This is the default setting for the big stuff, the core principles.
Yes. This uses the main Article 368 procedure we already discussed in detail, that two-part test of majority of total membership plus two-thirds of those present and voting.
And what falls into this much more difficult bucket?
This is for the heavy hitters. The most important ones are the fundamental rights.
So, freedom of speech, equality before the law, right to life and liberty. All the core rights of a citizen.
You want to touch those, you need to pass the special majority test. Also, the directive principles of state policy, or DPSP, the non-enforceable guidelines for how the government should run the country.
So the philosophical soul of the document.
Largely, yes. And basically, the source says this category is a catch-all for all other provisions which are not covered by the first and third categories. If it's not explicitly easy or explicitly hard, it falls here in the middle.
The text mentions a small nuance here about when the special majority vote is technically required.
Yes, it's an interesting procedural point. The text notes that, strictly speaking, the Constitution only requires the special majority for the voting at the third reading stage of the bill.
And the third reading is the final stage, the last vote before a bill is declared passed in the House, right?
Right. But the text adds that, by way of abundant caution, the rules of both the Lok Sabha and Rajya Sabha often require this special majority at all effective stages of the bill's passage.
Abundant caution. I like that phrasing. They don't want to get all the way to the end and fail, or risk a legal challenge later saying the procedure was flawed. So they apply the rigorous standard throughout the process just to be safe.
Exactly. It's a belt and braces approach.
Okay, so that's pathway 2, the standard for most significant changes. Now let's look at pathway 3. This is where the difficulty level ramps up from medium to hard mode.
Pathway 3 is amendment by special majority plus the consent of the states. This is the federal route.
And this is for when you want to mess with the fundamental federal structure, the power-sharing arrangement between the center and the states.
Exactly. Even though India has a strong center, there are certain lines that the center cannot cross alone. If Parliament wants to change something that directly affects the rights, jurisdictions, or powers of the states, they can't do it unilaterally from Delhi.
So what's the extra hurdle here? What does it take?
First, the amendment bill must pass through Parliament with the full special majority procedure we just talked about. Both houses, independently, clearing that high bar. But that's not enough.
What's next?
After it clears Parliament, the bill goes out to the legislatures of all the states in India, and it needs to be ratified by the legislatures of at least half of the states.
Half the states. Not all of them, just half.
Just half. And they ratify it by a simple majority in their own state assemblies. No special math is required at the state level.
Okay, so if India has 28 states, you need 14 of them to pass a resolution saying, yes, we agree.
Correct. And here is a critical detail from the source. The moment the 14th state gives its consent, the formality is completed. The bill can then be sent to the president for his signature.
So if the 14th state says yes, it's done. What if the other 14 states strongly object? What if they haven't even had a chance to vote on it yet?
It doesn't matter. The Constitution doesn't require unanimity or even a supermajority of states. If one or some or all of the remaining states take no action, or even if they vote to reject it, it is irrelevant once that 50% threshold is crossed.
That's a model of efficiency over total consensus. Again, comparing it to the U.S., where you need 3/4 of the states, 75%. Here, it's just 50%. It's a lower bar.
It's a lower bar than the U.S., absolutely, but it is still a very significant political hurdle to clear. Getting 14 or 15 different state governments, often run by different political parties, to agree on anything is a monumental task.
So what kind of changes require this massive effort?
As you said, anything that shifts power between the center and the states. The source gives a clear list, for example, the election of the president and the manner in which it is conducted.
That makes sense because the state's legislative assemblies form a big part of the electoral college for the president.
Yes. Also, any changes to the extent of the executive power of the union and the states, any changes to the Supreme Court and the high courts. And the big one, the distribution of legislative powers.
You mean the three lists in the 7th schedule? The union list, the state list, and the concurrent list.
Precisely. If the center tries to move an item from the state list, where states have exclusive power, to the concurrent list, where both can legislate, they can't do that without the states agreeing to give up that power.
The source also gives a very specific, modern example of this in action.
Yes. The Goods and Services Tax, GST Council. This was added by the 101st Amendment Act of 2016.
Oh, right. GST was a massive nationwide tax overhaul. It was probably the biggest change to Indian federalism in decades.
It fundamentally changed how taxes are collected by both the center and the states. It stripped states of many of their individual taxation powers and pooled them into one common system governed by the GST Council. There is absolutely no way that could have happened without the ratification of half the states.
Because it fundamentally altered the financial federalism of India.
Exactly. And there's a fascinating meta rule here, too, right at the end of the list.
What's that?
If you want to amend Article 368 itself, the very article that defines the amendment power, you need to use this third most difficult method. You need state ratification.
Oh, that makes perfect sense. It's a lock on the lock.
Yeah.
You can't use the amendment power to unilaterally make it easier for yourself to amend things in the future without asking the states first.
Precisely. You cannot unilaterally change the rules of the game to favor yourself.
Okay, so we have these three pathways: easy, medium, and hard. It seems incredibly comprehensive. But here's the big looming question that I'm sure is on every listener's mind. So what does this all mean? Can Parliament change literally anything if they have the votes?
If they get the special majority and they get the states on board for the federal stuff, are there any limits?
Yeah, can they turn India into a monarchy? Can they abolish the Supreme Court? Can they say, from now on, there are no more elections?
This brings us to Section 4, and it is arguably the most critical, most dramatic legal concept in all of Indian constitutional history. For a long time, the answer from Parliament was yes, and the answer from the courts was a little more hesitant.
That is not a comforting answer.
It wasn't, and this triggered a massive, decade-long tug-of-war between the Parliament, led by a very powerful government, and the Supreme Court in the 1960s and 70s. Parliament said, "We are elected by the people. Our power to amend under Article 368 is absolute. We can change any part of the Constitution."
And the court said,
The court, over a series of cases, started to push back, saying, "Not so fast." This all culminated in the single most famous and important case in Indian legal history. The source highlights it as the ultimate turning point.
The Kesavananda Bharati case of 1973.
It changed everything. A full bench of 13 judges sat for months, and by a razor-thin 7-6 majority, the Supreme Court laid down a new law. They ruled that while Parliament has the power to amend the Constitution, it cannot amend or destroy provisions that form the basic structure of the Constitution.
The basic structure doctrine. Explain that to me like I'm 5. What does that actually mean?
Okay, imagine you own a historic house. The law says you have the right to renovate it. You can change things. You can repaint the walls. You can modernize the kitchen. You can even add a new room in the back. But you cannot knock out the foundation pillars or the main structural walls.
Because if you do that, it's not a renovation anymore.
Right.
The whole house collapses.
Exactly. It's not the same house anymore. It's a pile of rubble. The court said the Constitution has a foundation. It has structural pillars. These core features, things like the supremacy of the Constitution, the Republican and Democratic form of government, the secular character, the federal structure, the separation of powers, the rule of law, free and fair elections. These are the basic structure.
So Parliament can repaint the rooms, but they can't touch the foundation.
You've got it. Even with 100% of the votes in Parliament and all the states agreeing, you cannot destroy the soul of the document. The power to amend is not the power to destroy.
That is a fascinating and incredibly powerful check on power. It basically implies that the Constitution itself is supreme, not the temporary will of the voters of the day expressed through Parliament.
Correct. It places the document's core identity beyond the reach of any government, no matter how popular.
Okay, we have the procedure, the 3 pathways, and now this ultimate safety valve of the basic structure doctrine. But, no system is perfect. Source material is quite balanced and lists some significant criticisms of this entire process. Let's run through these defects, as the text calls them, in Section 5.
Absolutely. Critics have definitely pointed out some serious holes and ambiguities in the system.
Criticism number 1. There is no provision for a special body for amending the Constitution.
Right. In the USA, for example, there is a provision for a special body, a constitutional convention, that can be called specifically and solely for the purpose of amending the Constitution. It's separate from the regular legislature.
So you have a different group of people for that specific job.
Yes. But India doesn't have that. Here, the constituent power, the power to make the Constitution, and the legislative power, the power to make ordinary laws, are both vested in the same body, the Parliament.
So the same people writing the traffic laws and the tax code are the ones rewriting the fundamental law of the land.
Exactly. And critics argue that this blurs the line between ordinary everyday politics and fundamental constitutional reform. It potentially gives the ruling party of the day too much sway over the permanent rules of the game.
Criticism number 2, the weakness of the state's role. We touched on this, but it's a major point of contention.
It is. The power to initiate an amendment is vested solely in the Parliament. It's a one-way street from the center to the states.
Unlike in the U.S., where state legislatures can get together and petition Congress for a convention.
Right. In India, the states are largely passive. They can only say yes or no when the center asks them to, and only in those very specific federal cases we listed under Pathway 3.
The text does mention one very small exception, though.
Yes, a state can pass a resolution in its assembly requesting the Parliament for the creation or abolition of a legislative council in that state.
The Legislative Council is like the state-level version of the Rajya Sabha, an upper house. Not all states have one.
Correct. But even then, the text notes that this is just a request. Parliament is not bound to act. They can either approve or disapprove such a resolution, or, as the source puts it, they may not take any action on it at all.
So even the one time a state can initiate something, Parliament can just ignore them.
Exactly. It underscores the subordinate position of the states in this process.
Okay, criticism number 3. The state ratification process is too easy.
This is a direct comparison point. Critics point to the half the states rule. They compare this to the much higher bar in the USA, where you need 3/4 of the states or in other federations. 50% is seen by some as too low a threshold for changing the fundamental federal structure of the nation.
And it also means a small group of the largest states can't block a change if all the smaller states agree, or vice versa.
It creates interesting political dynamics, certainly.
Now, criticism number 4, and this one seems like a genuine glaring loophole, the time loophole.
This one is a big one. The Constitution is completely silent on how long states have to ratify or reject an amendment bill that is sent to them.
So Parliament passes a federal amendment, sends it out to the 28 states, and then what? They just wait.
They just wait. The states could sit on it for a month, a year, 10 years. There is no prescribed deadline in the Constitution.
That's incredible. And the text raises another related question. Can a state withdraw its approval?
Right. Let's say a state legislature votes yes and ratifies the amendment. But then there's a state election 6 months later, a new government comes in and says, wait, we don't agree with that anymore. Can they pass a new resolution to withdraw their prior approval?
And the answer is?
The Constitution is silent. It's completely undefined territory. It seems like a recipe for legal chaos if it ever came to a contentious vote.
Absolutely. Okay, final one, criticism number 5, the scope for judicial intervention.
Critics argue that the provisions of Article 368 are, as the source says, too sketchy. They are brief and leave a lot of things unsaid.
Like the basic structure doctrine we just discussed.
Yeah.
That's not written in Article 368. It was created by the court.
Exactly. Because the text leaves so much open to interpretation, it leaves a very wide scope for the courts to step in and become the ultimate arbiter of what is and isn't a valid amendment.
It gives the judges a huge amount of power to interpret the rules.
Which leads to this constant simmering friction between the parliament, which claims to represent the will of the people, and the judiciary, which claims to be the guardian of the Constitution. It almost turns the Supreme Court into a third legislative chamber.
So those are the flaws. No special body, weak states, an easy ratification bar, a time loophole, and too much power for judges. It sounds like a broken system. But let's look at the defense. The source material argues that despite these defects, the process has actually, on the whole, worked.
It has, remarkably so. The text argues that the process has proved to be, in practice, both simple and easy enough to meet the changed needs and conditions of a rapidly developing country.
There's a great quote here from the constitutional scholar Granville Austin. He says, "The amending process has proved itself one of the most ably conceived aspects of the Constitution. Although it appears complicated, it is merely diverse."
Merely diverse. I love that. He's not seeing the complexity as a bug. He's seeing it as a feature. It's a toolkit. It allows you to use different tools for different kinds of problems.
You don't use a sledgehammer to hang a picture frame, and you don't use a tiny tack hammer to break up concrete.
That's the idea. And Casey Ware, who we mentioned at the very beginning, echoes this. He says, this variety in the amending process is wise, but rarely found. He sees it as a sign of sophisticated constitutional design.
So the defense is that it finds that perfect balance. It prevents the ruling party of the day from changing the fundamental rules of the country on a whim. That's the rigidity from the special majorities.
But it also allows for necessary adaptation to new social and economic needs. That's the flexibility from the simple majority path. It bends so it doesn't break.
And maybe that's why it has survived for over 70 years, while so many other post-colonial constitutions have been thrown out or have failed entirely.
That's the argument. It has endured.
So we have traveled all the way from the philosophical spectrum of Britain and America to the gritty mathematical details of Article 368. We've done the math on special majorities, we've navigated the 3 pathways of easy, medium, and hard, and we've looked at the ultimate judicial shield of the basic structure doctrine.
It shows that the Indian Constitution is not a static text. It's a living document, protected by a complex, multi-layered, and sometimes confusing legal framework.
It's not a stone tablet, and it's not a Google Doc. It is something uniquely and perhaps messily in between.
A true synthesis.
Before we sign off, I want to leave you, our listener, with a provocative thought to mull over. We mentioned that time loophole, the fact that the Constitution sets no time limit for state to ratify an amendment.
It is a fascinating and potentially dangerous silence in the text.
So imagine a scenario. A future government passes a hugely consequential amendment that requires state ratification. It's controversial. It squeaks through Parliament. It goes to the states. And half of them ratify it quickly, but the other half? They just don't. They neither say yes nor no. They just wait. The amendment hangs in constitutional limbo for years, maybe decades. Is that a bug in the system? A terrible oversight?
Or is it a hidden feature? A silent pocket veto given to the states? Is the ability to just delay indefinitely the ultimate check on a powerful central government a way to ensure that only changes with true, urgent, and overwhelming momentum actually happen?
Is that silence in the rulebook a bug, or is it a feature?
That's something to think about. Sometimes in politics, doing nothing is the most powerful act of all.
Thank you so much for joining us on this Deep Dive Daily.
It was a pleasure unpacking this with you. A really fascinating topic.
If you enjoyed getting into the weeds, unpacking the legal framework of the world's largest democracy, and really looking at the gears of Article 368, make sure to like and subscribe to the channel Deep Dive Daily.
We'll see you in the next deep dive.
Stay curious.